Hello, and thank you for joining me for this introduction to designs. This is one in a series of talks that Gill Jennings are offering. And if you find this interesting and want to find out more, look out for the other talks that we have available online. So my name is Chris Anderson, and I'm a patent and design attorney at Gill Jennings Every. I've worked here for over 6 years now, and I'm head of GJE's Designs Group. Over those 6 years, I have spent a lot of time advising clients about their designs, with one of my major clients being Hasbro, who I've advised in relation to their Nerf range of guns. And we'll be seeing a few examples of their designs later on in this talk. Gill Jennings Every are a specialist IP law firm based in London. We handle patents, trademarks, and designs, which will be the subject of this talk, both in the UK through our London office and in Europe through our Munich office. So here's an overview of what we'll be discussing today. So firstly, what are designs? We'll also go into what are the differences between the two different types of designs, registered and unregistered. We'll look a bit at how you can rely on unregistered design rights. We'll go into how you can obtain registered designs. And finally, we'll look at the impact of Brexit on designs in the UK and Europe. So firstly, what are designs? Well, designs are a type of intellectual property right that protects the way something looks. And this is very important in the marketplace as companies spend a lot of time and money making sure that their products look right. Design rights are there to ensure that this investment that companies make is protected. So what actually is a design though? So definitions of this will vary around the world, but generally they mean roughly the same thing. The UK definition there is that a design is the appearance of the whole or part of a product. And this definition gives a non-exhaustive list of features that can contribute to the appearance of a product. So there are lines, contours, colors, shape, that sort of thing. Now, a product doesn't need to have any one or all of these in order to qualify for design protection. However, these are just examples of the kind of things that can be protected using design rights. And so what do? Well, design rights are there to allow you to stop others from selling products that have the same or a similar appearance to your protected product. So as mentioned before, there are two main types of design right, and these are registered and unregistered. We will look at these in much more detail later on in the talk, but very briefly, registered design rights require an owner to file an application at an intellectual property office, usually before their design is disclosed, whereas unregistered design rights are a type of right that exist automatically, as long as the circumstances qualify the product for unregistered protection. But as we will see later, there are a few caveats that generally make these less useful than their registered counterparts. So what can a design protect? You may have seen in the legal definition that we looked at earlier that designs apply to products or parts of products. But this doesn't just mean that designs apply to objects that you can sell, off the shelf. Many things actually fall under the legal definition of a product. In my own words, I would say that if you can see it and thought has been put into how it looks and not just how it works, it's almost certainly going to be suitable for some kind of design protection. So we'll look at a few examples now, and these are all products under the legal definition, and these images have all been taken from the Register of Designs. This first one is a shirt that has been protected by Nike. And if we think about what I just said, this is something you can definitely see, and they've definitely thought about the way this looks. And so design rights are there to protect this investment that Nike have made in the appearance of this shirt. One interesting thing to note about this is that this appears to be a sports jersey, but without any of the badges or logos that you would expect to see on there. Now this reflects some of the flexibility that you have in how you go about protecting the design of products with registered designs. And this is because Nike very likely don't want to limit this product to being protecting any one particular team. And so they're instead trying to protect the underlying design of the shirt. And we'll come on to some of the other things you can do with registered designs later on in the talk. Another example, this one fairly self-explanatory. This is a necklace. Again, this is something you can see, and they clearly thought about the way this looks, and so this is suitable for design protection. Some of you may recognize this. This is the iPhone 11. Now, Apple highly values the appearance of its products and invests a lot of time and money in making sure that they look right. And so they make full use of design rights in order to protect this investment that they make. The Pringles logo, this is also a product under the legal definition. And this is protected as a registered design in addition to being protected as a trademark. So these two different types of IP provide different sorts of protection. Briefly put, designs protect the overall impression of something, its overall appearance, whereas a trademark requires there to be likely confusion between the commercial source of two products. As I mentioned before, there is also a talk in this series on trademarks, and you can find more details of that online. Packaging is also protectable with design rights. Here we have packaging for a Cadbury's chocolate bar. Again, you will notice that the branding here has been removed, and Cadbury's are instead interested in protecting the underlying packaging design. And again, this reflects the flexibility that you have with how you protect the design of your product. The chocolate bar inside the packaging is also protectable. Again, this is a Cadbury's registered design. But if we think about the test I proposed earlier, this is something that you can see, and they've certainly thought about the way it looks, and so it is suitable for design protection. Even buildings count as products under the legal definition, and this looks to me like someone has protected the design of the Notre Dame with a new roof. But again, it's something that we can see, and they've thought about the way it looks, and so it's suitable for design protection. As well as the outside of buildings, you have the inside of buildings. So this is a storefront in the shop window of a cheese shop. You can see that careful attention has been paid to the way this looks. And you can imagine that the shop owner would be quite annoyed if a shop opened up a few doors down that had a very similar looking front. And so again, this is something that can be protected using designs. Final example here, we have animated characters. These are also products under the legal definition. And this is an updated design of the Noddy character. And what should be clear here is that designs don't need to protect only products that you can see and touch in the real world, and can also protect things that you only see on a screen. Other examples would be graphic user interfaces and animations, for example, all protectable with design rights. So who is entitled to these rights? Well, the rights of a design belong firstly to the designer of the product. At least in the UK, there is an exception, which is if the designer is employed to design the product, then the employer will instead automatically own the rights. One thing to be careful about is the commissioning of the design of a product. If you commission someone to design a product for you, even with heavy direction by yourself, they will own at least some of the rights in the design under UK law. Now what you'll need to do here is ensure that there's some agreement in place that transfers their rights back to you. Okay, so let's go on to a more detailed look at unregistered design rights. Okay, so there are two main types of unregistered design right that currently affect the UK, and the first is UK Unregistered Design Right, or UDR. So this is a type of right that is automatically generated when the first article is produced according to the design, so for example, a prototype, or when the design is first recorded in a design document, be that a design drawing or a CAD file of the product. In order to be generated, the design must be original, which means that it must have originated with you, and it cannot already be commonplace on the market. Importantly, UK Unregistered Design Right protects only against copying. So in order to enforce this right, you'll need to be able to prove that an infringer has copied you, which can be something that is quite difficult to do unless it is a very blatant copy. UK Unregistered Design Right protects the shape of 3D articles only. So if we think about our Nike shirt, this is a product which comprises both 2D and 3D elements. So you have the overall shape of the shirt as well as the the patterning that is applied to the shirt. Now, under UK unregistered design right, only the 2D part of the design will be protectable. So if you take away the printing that's applied to the shirt, then what you have is very unlikely to be considered not commonplace in the market. This is a very generic shirt shape, and so it's unlikely that this shirt will benefit from any meaningful unregistered design right. So UK unregistered design right lasts the shorter of 10 years from the first sale of the product, or 15 years from creation. And what this can mean is that if it takes you a long time to bring your product to market from, for example, the first time you recorded it in a design document, you may have limited the length of protection available to you through this type of right. One thing you should also know is that there is an obligation to license your design in the last 5 years of protection. So what this means is that if another party wants to produce your product, then in the last 5 years of your UDR protection, you won't be able to stop them. The only thing you'll be able to do is insist that they pay you a royalty to do so. Okay, the second type of unregistered design right affecting the UK currently is unregistered community design right. And you will start to see some asterisks here which reflect the impact of Brexit that is going to come into effect at the start of next year. That's 1st of January 2021. We'll come on to later in the talk the specific effects of Brexit. But for now, what you need to know is that unregistered community design right is generated by the first disclosure of a design in the UK or EU. Now, not any disclosure will do to generate this right. This disclosure must reach the relevant sector. So, for example, a disclosure of your product to a friend will probably not be considered to reach the relevant sector, whereas advertising the product in a magazine, for example, likely would be considered a sufficient disclosure to generate the right. In order for this right to be generated, the design must be new and have individual character. Now, these are the same requirements for registered designs, and we'll come on to them in more detail a bit later. But generally, this just means that there is nothing exactly the same as your design already out there, i.e. new, or nothing that is substantially the same already out there, so that's individual character. So this type of protection currently provides protection across the UK and EU. But again, this is a type of protection that only protects against copying. So again, you would need to be able to prove that an infringing article was made by directly copying your product. So this type of protection is effective for 2D and 3D articles. So the Nike shirt would be protected by this right once again. Finally, this type of protection only lasts 3 years from the first disclosure. And it should be clear from this that unregistered design rights are most useful for products with very short lifetimes, as they don't last very long. So that's items such as fashion items. If you want any more information, you can head over to our website there. And if you have any questions, please feel free to email me. My email address is there, or contact me on LinkedIn. You can see my handle there on LinkedIn.